Okay.
Okay, now, I'm just wondering, though, again, and I think this is something that members of the PDP have also raised in terms of, judgment being delivered on a Saturday. They say that barely had the written addresses been given by both sides, and then the following day you had the lawyer, I beg your pardon, the chairman of the tribunal delivering judgment on a Saturday.
There is nothing wrong with giving judgment on a Saturday. The tribunal has been hearing cases on Saturdays. It has, in view of the 180 days, in view of the fact that election petitions are of a peculiar character and nature. So if the tribunal has been sitting on Saturday, hearing proceedings, taking evidence, and the PDP lawyers participated, they did not say anything, why are they now saying that deliver judgment on a Saturday?
Okay, in addition to that, they also say that after the adoption of written addresses on Thursday,
yes,
and then on by both councils, and then on Friday, they were notified by the judge that the judgment was going to be delivered. So they wonder, how could he have gone through hundreds, maybe about 200-300 pages of written addresses, and then in less than 24 hours deliver judgment? So they are alleging that it means that the judgment may have been ready before the adoption of written addresses.
I don't think so. The written addresses are not compulsory. The court sometimes dispenses with written addresses. So I do not think that the tribunal do not even look at the written addresses. That is a very wrong presumption. Were they there when the judges were going through the documents or looking at the legal authorities and so forth and so on to write their judgment? They cannot prove that those written addresses were not read by the members of the tribunal. In any case, there are instances where the court can dispense with the issues formulated by counsel for the different parties and formulate its own issue, like the Rivers State case, or the case we are talking about. The tribunal formulated its own issue, whether or not the petitioner has proved his case, and it answered in the affirmative that the petitioners have proved their case. So maybe after reading all the written addresses, but written addresses is not fundamental. The judgment cannot be nullified because of the allegation that the tribunal did not read the written addresses. That fact cannot be established. It's just an allegation.
Okay, let's get your thoughts on this matter.
Just assuming that because the written addresses were adopted on a Friday and the judgment was fixed on a Saturday, that means the tribunal did not go through their written addresses. I think they went through the written addresses, and from all because of that, they formulated an issue for determination, which they answered in favor of the petitioners.
They also raise eyebrow because they think that first, although you said they can deliver judgment on Saturday, no problems with that one, but they say if they have a 7-day window with which they have to deliver the judgment, and then there's going to be a Supreme Court ruling, I think that's what they say, on Tuesday about the question of jurisdiction. Why did they have to deliver that judgment real quick on a Saturday? Couldn't they have waited till Tuesday's decision is delivered before this judgment? Because if the judgment on Tuesday says or is in favor of the PDP's priors, it means that this judgment will be invalidated.
Well, fine, if it is in favor, but in the election petition cases, an appeal does not operate as a stay of proceedings. It is provided in the first schedule to the Electoral Act that on no account should an appeal operate as a stay of proceedings. So the fact that the matter was in the Supreme Court, or the appeal was pending in the Supreme Court, does not operate as a stay of the proceedings of the tribunal.
But what effect could he have had? I mean, if, for instance, it had been in favor of the PDP?
If the Supreme Court judgment will be in favor of PDP?
Yes.
Fine. If it is in favor of PDP, that ends the matter, because If the Supreme Court says the tribunal doesn't have jurisdiction, fine, that ends it. That means the petition is incompetent, the court, the tribunal doesn't have jurisdiction, and then the petitioners will go home.
But isn't that going to raise more question marks on the judiciary?
Well, the constitution has to be amended, the electoral act has to be amended, because this election, the Supreme Court saying that, the constitution saying that you have 180 days to hear the petition. It's a very, very difficult thing. Taking into account the fact that our country is underdeveloped, we don't have so many judges and so forth and so on. All the other challenges you have to go through to hear a petition, to prepare and present a petition for hearing.
But why do we have to amend the constitution when discretion could have been used here, saying, look, if it goes this way, it raises questions. So it's just a question of discretion and not necessarily an amendment of the constitution.
Well, the 180 days is a challenge. I know that in the 2011 election, the cases that went to the Supreme Court said you cannot, do anything outside the 180 days. So the law is dynamic. Law is not static. Maybe because of what we have seen in 2011, 2015, there should be a look at that provision of the Constitution that says a petition must be heard within 180 days. It places the petitioners and the tribunal in a very, very, very tight corner.
And then the other part, maybe just before we wrap up, they also have issues about much as, yes, the Court of Appeal constitutes the panel, they raise questions about does the President of the Court of Appeal, as much as they have the powers to set up the tribunal, do they tell them where to sit as well?
Are you talking about venue?
I'm sorry, I didn't get that.
Okay, are you talking about the venue?
Yes. The location.
Yeah, and they went to the Court of Appeal, and the Court of Appeal ruled against them. I know that the River State and Akwa Ibom challenged the movement of the tribunal from Uyo in Akwa Ibom State to Abuja, and then from Port Harcourt to River State, and they lost. So if in the discretion of the President of the Court of Appeal, if the atmosphere in River State or Akwa Ibom State is not conducive for members of the tribunal to, hear the petitions, so I don't think there's anything wrong changing the venue to Abuja. Does that prejudice the respondents? I don't think it has prejudiced the respondents.
All right.
But we have to show that they suffered a miscarriage of justice for the Supreme Court to reverse that. Going to Abuja, they suffered a miscarriage of justice. I don't think they suffered any miscarriage of justice.
But don't you think that, for instance, they could argue that they could have brought more respondents, but for reason of travel and distance, they couldn't, afford to bring those people. Those kinds of things could actually have an effect on the case.
Well, it is not the respondents that should make that argument. It should be the petitioners who are aggrieved. And the petitioners have not seen anything wrong with the movement. The movement is just to give a conducive environment for all the parties to present their cases. I do not see anything wrong with that, because it is in consonance with the principles of fair hearing provided for in the Constitution, that a party to a matter must have a conducive atmosphere to present his case. You should not, witnesses should not be afraid of going to court to give evidence, because if they are afraid, it will result in a perversion of justice. So witnesses should be free. So if the atmosphere in Port Harcourt or Uyo is such that the witnesses will not be free to go to the tribunal and give evidence, then there's something wrong with the President of the Court of Appeal moving the tribunals to Abuja.
All right, then, Mr. Obono-Obla, legal practitioner and member of the Legal Directorate of the APC Presidential Campaign Council. Thank you for talking to us today.
Thank you.
All right, and we'll be back in a moment. Don't go away.